Hello everyone, and welcome to another podcast of Tech Prosecutor. Today, we have with us Mr. Anis Zaidi from Saudi Arabia. He is the founder of Privacy Pulse Consulting INC, and today he will be shedding some light on the data subject rights under the Saudi PDPL, that is the Personal Data Protection Law. So, Mr. Anis, would you just set the stage that what is the PDPL and how has it till date helped the data subjects to enforce their rights?
Sure. First of all, hi to everyone, all the viewers. And coming to this Saudi PDPL, which is a personal data protection law, you see, it was first enacted by a royal decree in September 2021. Then in March 2023, an amended version came and it remained open. It was waiting for, in fact, for the implementing regulations. And in September, if I am not wrong, implementing regulations were published, and this law was implemented on 16th of September 2023. But the government and the regulatory authority, which is Sadaya, they gave 1 year time for the data controllers, any organizations to prepare themselves. And finally, it was in last year on 16th September 24. So this is the background. And during this period, yani from 23 to 24, what Sadaya did that they issued many guidelines. For example, guidelines for the appointment of data protection officer, guidelines for controllers, guidelines for the processors. And during this period, implementing regulations was also slightly amended, and previously, the cross-border data transfer portion was attached with the implementing regulations. What they did, they issued a separate amended cross-border data transfer regulations. And under those, they give the guidelines that what the procedure for the cross-border data transfer, for example, through standard contractual clauses. They published a standard contractual clause that similarly binding corporate rules if the data transfer is within the organizations overseas. Similarly, they say that they will publish a education list of the countries which is still awaited. So this 1 year period Sadaya used to issue these type of guidelines and regulations. Now, if you come to this specifically, which we are talking about for data subject rights. So yes, so this implementing regulation as well as the act, they provided certain rights to the individuals. Individuals means the data subject. Data subject means the persons whose data is being processed. And just to explain and clarify that this processing of the data starts from the point when any organization collects the data. For example, I am going to a service provider. You see, for example, this courier company. And courier company, he asked me my name, my address, my mobile number. So as soon as they ask for this information, this processing starts. They take the data, they keep the data, they transfer the data to another organizations, then you use this data. This is all the processing. So processing starts specifically from the point when the data is collected. So now coming to this data subject rights, like this other regulations and laws, for example, GDPR, PDPL has also given certain rights individuals whose data is collected, and these are the set of legal entitlements which PDPL has granted to the individuals that whose personal data is being processed. And these rights, they empower the individuals to control over how their personal data will be collected, used, and shared, how long it will be kept, when it will be destroyed. So this type of specific information, it creates a transparency and accountability and the trust also between the persons whose data is processed and the organization who is processing the data. So this type of relationship this law has created, which is also in the GDPR. And in fact, what happened that essentially these rights put the people whose data is being collected and not the organizations at the center of the ecosystem. So this is the background in which they have this given the rights to the individuals under the regulations and the act.
Thanks
Yes.
a lot for that comprehensive explanation. So, what are some specific data subject rights, according to you, that the PDPL emphasizes on, and are they in consonance with the global data privacy standards?
Yes, a good question. They are almost similar to the other regulations, for example, GDPR, and but there are some situations which are, I can say, the because of the culture they have added something which I will explain to you later. But first we see what are the those specific right which has been given in the PDPL. So if you see the Article 4 of the PDPL, you will find there specifically they have listed 5 rights, starting with a right to be informed. What is right to be informed? Right to inform means that the data subject, the person whose data is being collected, he should know how their data will be collected, used, and shared. Each and every detail should be very transparent. What data you will collect from me, where you will share it, what you will use for it, and whether it will be shared cross border also, and when this data will be destroyed, or if not destroyed, how it will be archived. So all this information should be given, and this is given as a right to the data subjects. The second right, which is listed in Article 4, it is the right of access. And if you have taken data subjects information, then the data subjects, they have right to access their personal data held by the controller, of course in accordance with the rules and procedures which are set in the regulations, but they have the right to access their information. The third right they have given is the right to obtain. Yani if as data subject, he want to obtain the information which an organization is keeping, then he has the right to go to the organization and say, whatever information you have, please provide me. And it is the responsibility and the obligation of the data controller under the regulation to provide that information in a readable and clear format. If he has asked for the digital form, they should provide in the digital form. If he has asked for in a physical form, then they should provide in a physical form. Of course, there are some guidelines and procedures provided in the regulations. They have to keep that in mind. The fourth right is the right to correction or update. For example, data subject information is changed, his address is changed, his phone number is changed, and his availability, for example, is changed. Then he has a right to go to the data controller and say, look, my information has changed and you have to correct my information in your system. Or in case the organization, they themselves found that there are some inaccuracies in their data, then by contacting the data subject, they have to make their information accurate. And lastly, the fifth the right which PDPL has given to the data subjects or the persons whose data is collected is the right to deletion. I can request for as a data subject, I can go to a processor and say, as a controller, and say that look, my data is no longer required, so please delete data from your system. Or, for example, I have given a consent for something, I can withdraw that consent. Of course, again, as per the rules and regulations and the procedure provided in the regulations, implementing the regulation. Now, in addition to these specific 5 rights, I would like to mention 2 rights also which are not listed in this list, but they are the procedural derivative rights, I always say. The first is the right to give a consent. For example, no information will be processed by a controller or a user without the consent of the data subject. And this consent should be very clear and inform you that it should be informed consent. So in this way, each subject, they have a right to give the consent, although it is not listed in the list above under Article 4, but it is a derivative right which is given under Similarly, another right which comes also from the procedure is the right to withdraw the consent. If I have given consent, I can withdraw the consent. But again, subject to the rules and regulations which are provided in the implementing regulation. So these are the five rights which are specifically mentioned, given in the Act, and there are two rights which are derivative rights because of the procedures.
Could you please explain that what the right to be informed really means in practice? Because I believe there is a little bit difference between right to be informed and right to access.
Yes. You see, a right to be informed and a right to be accessed, they are overlapping, I can say. First, take the right to be informed. The right to be informed means that organizations, they must clearly inform individuals. Clearly means transparently, without any ambiguity. They should inform individuals that why their data is being collected, what is the purpose of data collection, and who will access their data, where they will give it to them, whether it will go to the third party, and how long it will be stored, and what rights they have. And this normally we provide through a privacy notice. You must have seen in the websites of the service providers or the companies who collect data either directly or through cookies, etc. They publish a privacy notice. Although in the PDPL it is, they have termed it as a privacy policy, but privacy policy and privacy notice is different. Privacy policy is a internal policy in the organization, that how when they receive the data, how they will handle it. But in the PDPL, they have given in for this purpose, privacy notice purpose, they have use the word privacy policy, but we should know that this is a privacy notice, and this information should be provided through a this notice, which will be in a very clear and simple language. There should not be legal jargons, because the person, ordinary person, they cannot understand the legal words and legalities. So it should be in a very simple language. And as you must know that in this our Indian DPDPA, they have given it will be in the local language also. For example, if the organization is in the south, for example, so they should provide in the local language also, because the general public, they can understand that why my data is collected, who will access it, what they will do, how long they will keep it, when they will destroy it. All this information should be very clearly, because this gives a transparency and the trust, as I mentioned earlier. But when I know as a user, I know that the organization is taking my information, and he has given me very clear information that what they will collect, what they will do, where it will go, how long they will use it, and how they will dispose of. Then I will build a sort of trust between myself and the organizations, and I will not hesitate giving my information to the organizations, and it will help in the businesses also. So this type of trust will be created through this transparent information. Now, coming to right of access, this is very powerful also, because while individuals can request a copy of their data, organizations can sometimes they deny. For example, if I am going to the organization repeatedly, I have taken the information again after 6 months, I give my information. So if the organizations feel that this individual is coming repeatedly, is asking the same information again and again, then they can refuse it. And then if it is excessive also, or if it involves such information that will disclose the information of others also, and it is not possible to exclude those two information, then they can say, they see, we cannot disclose this information because it will disclose the person information and others also. Or for example, there is a legal binding on them, that there is a court case, and there is a order from the court that no, you cannot share this information, so they have to bind by the legal orders. Similarly, if they are contractually obligated to form anything, then they can say, okay, no, we will wait for some time for giving you this information, or before destroying the information or deleting it from our system.
Yeah. So
With this, we can, yeah, please, yeah.
I was just asking that what happens when someone wants their data to be corrected or deleted?
Yeah, partly I have covered this in the earlier question, but again I will say that yes, if somebody comes to the organization and say that there is a inaccuracies in the information which you are holding, or there is a update in the information, my address has changed, my mobile number has changed, or my timings, for example, have changed, and we want to change it, then yes, they have right to go and correct that information. And when it comes to deletion, yes, deletion, as I said, that if this information is required to be retained for legal obligations, for example, or the contractual obligation, for example, there is a contractual obligation between the data principal and the controller, and that obligation is not completed, then the organization will say, look, I have to complete this contractual obligation which I am with you. So now I cannot delete this information. Let me finish this obligation on me. Then I can, yes, we can review and we can delete this information. So these two, three conditions are there when they can refuse or they can delay the deletion of the information, personal information.
You mentioned right to withdraw consent as a derivative right within the PDPL. So, what should
Yes.
organizations do when someone wants to withdraw their consent?
Yes, you see, if the processing is based on the consent, because if I will go in on this legal basis, so it will take more time, because in the Act there are different legal bases on which information can be processed, personal information can be processed, and consent is one of those. No, I will say that consent is the main and others are the exception to the consent. So this consent, they have the right to withdraw the consent, but they can, yes, they can withdraw it anytime without needing to justify. And once this withdrawn, organization must immediately stop processing the data unless there is another lawful basis. For example, they have a legal duty, or they have contractual obligation, or there is a term we call legitimate interest of the organization, which overrides the rights of the individuals whose data is processed. In those situations, they can refuse to withdraw the consent. And but as a best practice everywhere, under the GDPR, under the PDPL, everywhere it is a best practice that this withdrawal of the consent should be as easy as to receive the consent. There should not be complications, that you do this, you do this, or you do this, or you go to my this side, or you go here. No, it should be very simple and straightforward. And then with this one, I would like to go to something that, suppose a request is received from a data subject, maybe it is for the for the consent withdrawal, or it may be to access their data, or to delete their data, or to obtain their data. So what organizations normally they should do? In fact, I prepared a flow chart which, if I share it, will be very helpful here. Let me see where I put it, because I worked very hard in preparing that chart, that how this when we call it as data subject access right. Sorry, the DSAR request. So as soon as an organization he receives a DSR, either electronically or in writing, then the first step which they have to take is to verify the identity of the data subject, to ensure that they have a right to, that this person has a right to access. Maybe as a data subject, I am not going directly. I am authorizing someone. I am giving a mandate that yes, on my behalf, this person will access my data, make a request, DSR, he will make a DSR. So at that point, I have to identify either the original data subject or the person who has been authorized. Then, as soon as I received the DSR, immediately I sent them a acknowledgement request, because under the regulations they have given a time to respond to the data subject request. Normally, it is given 72 hours. So there should be immediate the acknowledgement that yes, today at this time I received this DSAR. Then I will also know that within 72 hours I have to respond it. Then I will this the organization, they will assess the request, that what request has been made. It is for deletion, or he has asked for some information, access, he wanted to access it, or he wanted to obtain it, how he had to obtain it, what is this information. So we have to assess the request, evaluate this, what is the scope and what is the nature of the request, to find out the information from our system, from the organization system. Then the organization, they retrieve the data from the system. Wherever it is stored locally or in the cloud, they will retrieve this data, and then after retrieval they will review the data, that yes, this is the data which was specifically requested by the data subject under this DSAR. So before releasing, so there must be someone accountable and responsible to review the data. Then we should consult the legal consultation also. If it is necessary, we can go to the legal counsel and experts to ensure that it complies with the data protection regulations and the act. Then the next stage comes the preparation, prepare the response. There should be a comprehensive response that include the request information or the explain if we are refusing it, because there can be a refusal also. So there should be a reasoned refusal, that we are refusing to give this information to you, or we are refusing this your DSR on these grounds, which should be very, very reasoned. Then we will, of course, we will, when everything is clear, then we will send the response. And after that, we will document all the process, is right from receiving the DSR until its disposal. So then the next is data deletion. For example, if he in his request, he has requested to data, and finally the organization, they come to the conclusion that yes, we can legally delete this data, then we will delete the information in the system. So this is the DSR process which I wanted to share with you, because this is very important for the data subjects as well as the organizations. Yes, please.
What happens if an organization refuses or delays responding to a request?
Yes, the organization refuses or delays this data subject, they have right to go and go to the super authority. For example, in PDPL, it is Sadaya. They can go and they can file a complaint. They have a this platform. Sadaya has created a platform. They published the regulations, acts, and guidelines, and this. There is a provision for the registration also of the organizations. So in that platform, there is a email which can be used by the data subject to immediately complain if they have any grievance.
So, do all these rights apply to all types of processing activities, or are there any exceptions or any limitations to this right?
No, this PDPL is if it is a personal information, then the PDPL applies to all the personal information. It can be your for example, financial information. So PDPL has a different a special article on the processing of the credit data. Similarly, they have a special provision for article for the processing of health data. So all the performance, it applies to all the information. This PDPL.
How should
But yes, there are some. Yeah, please go ahead.
No, you may continue. I think you were adding something.
Yeah, I was adding that these right to apply these rights apply to all types of data processing, but of course there is a balancing between the data subjects and the organizations. For example, if the data is processed for national security, crime prevention, or judicial process, some rights may be restricted. They say, no, we cannot disclose information to you, we cannot share this information, or we cannot give you access to this information, or we so in such situations they can it can be refused. So the subjects along with the national security and broader social aspects. Yes, please.
So, from your experience, like you have been practicing data privacy in Saudi Arabia. So, do people in Saudi Arabia actively exercise their data rights yet?
If you see, as I told you, this uh, act and this PDPL, it was implemented in 2023, September 2023, with the enforcement a period of 1 year, which ended on 2024 September. And Sadaya, on their part, they have done a lot of work issuing the guidelines and regulations and advices and all these things. And they are spreading the awareness also. But still, personally, I see a lack of awareness at the larger scale. Big organization, yes, they are working on it, and they have set up the procedures and they have complied. But at the ground level, for example, smaller organizations and the general public, there is a lack of awareness. And I hope that with the passage of time, because it's very new, if you compare for example, GDPR, it's now almost 7 years now. So it will come up. And I think it's the responsibility of the privacy professionals also to spread the awareness among the masses. Just for example, they can go to the schools, because schools and colleges and universities, they are also covered at the PDPL, because they collect the personal information. They can go there, they can have some small sessions there, they can guide the students, they can guide the students how to use the social media platforms, what information they should not display or share on these platforms. So this type of guidance and advices should be taken care of by the privacy professionals. They can go to the hospitals also. They can go, or they can have a sort of seminars and workshops or the webinars to spread the awareness. There is a dire need to spread the awareness. Awareness is lacking everywhere. Not only in this region, everywhere. Even if you see in India, if you go to the general public and you say, do you know about the DPDPA? No, they don't know about it. So India is a very big country. It will take some time, but in the smaller areas, for example, it can be done in a fast and in a structured manner. And here, Sada is also doing a lot of work, and we can collaborate with Sadaya also. So the awareness is growing, but it's still there is a lot of work to be done.
Believe that
So yeah,
awareness that you just discussed right now, I think that is what we are trying to do through the medium of this podcast, and I hope that this really reaches the Saudi population. So, what is your final message to listeners and the viewers of this podcast about protecting their personal data?
yeah, I will advise them to be always curious and cautious. Curious, they should inquire whenever anybody asks for their information, personal information, whether it is a digital or the physical platform. Immediately they ask why I should give. They should start thinking themselves why I should share this information, what they will do, why they are asking for me, and they should put up the question also. You must have also experienced that when we go to our retail stores or the mall or the shops, if at the billing counter, the first thing they will do, that what's your sir, what's your mobile number? What is he will do more with my mobile number? I came here to purchase an item. I have purchased it. I have paid it. Give me the receipt. I will go back. If there is a situation when I have to exchange it, I will come with a receipt to the exchange or to file a complaint about this product. Okay, if you have any customer loyalty program, for example, okay, give me the link. I will go there. I will register myself. I will give my consent there. I will whatever personal information I think that I should give, for example, my name, my mobile number, my email. I will give there with my willing consent for a certain purpose. But here at the billing counter, you are asking my mobile number. What he will do? Why should I share it? So this type of curiosity and cautious should be there. And if this awareness comes among the users, only then it will happen. So it is very necessary to spread the awareness now, because previously this data exchange was very limited. Uh, but as soon as this internet came and digitalization happens, and now there is a cross-border data transfer at the click, you data can immediately it can travel thousands of kilometers, I can say immediately. So in this situation, the whole perspective has changed now. We have to be very careful. I have seen people, they carelessly they share their personal information, personal photographs on digital platforms. And they not only for themselves, for their kids also, and without taking precautions. For example, okay, if you are on a Facebook, at least keep your account not public, keep it a private. Although it is not private, in my sense, it is not private because anybody can get. There are guys who can access your account also, but we should be take cautionary. We should be very curious. We should be very always. We should question them. Why you are asking my information? Why should I give it? And although I know that in today's world, it is very difficult not to exchange the personal information, because if I wanted to have service with someone, then I have to share it. And if I will not, that, for example, that service is very necessary for me. For example, I go to the hospital, okay, and I need some service in the hospital. I have to give the information. I cannot say no. I cannot give. I have to give them. Similarly, as I gave you the example of this courier service, I go to the courier service. I say I've sent this packet to my friend in another city, for example. Then I have to give the information for myself and my friends also. So there is this type of situation has developed, which was not previously, I can say, maybe 100 years back or so. But now, as the technology is developing and new perspectives are coming, so we have to adjust. But in that scenario, we need to be very, very cautious, curious, questionable, with our mind and eyes open always. That why they need their information, because what is happening? See, there are some brokers also. They for the analysis purposes, they sell the data to the companies. So this our personal data they collect from here, from there, and then they analyze this data, and then they give information to another companies for marketing purposes or whatever it is. But without our information, our data is being sold in the market. So we should be very careful about sharing our information, and this can happen only if we continuously spread awareness and spread awareness from the ground. For example, from the children, I have seen the parents, they don't fix their iPad, they don't make any control over their. But, knowingly or unknowingly, these kids they are sharing their information. They are opening the accounts. So these things are very, very serious. And the parents should be educated. The children should be educated. They should know that what will happen with our information. So this is the thing which I can say, an advice.
Thanks a lot, sir, for taking out time on a weekend and giving such a comprehensive explanation of data subject rights under the PDPL. And I hope that we are also able to spread awareness through our platform. And all these statutory guarantees are actually translated into practice as soon as people are aware of their rights?
Yes, of course, of course. So thank you very much, and for such a wonderful topic. First of all, selecting such a wonderful topic and recording it, and of course you will share it. And this type of things we should do to spread the awareness. Podcast, interviews, and webinars, and open sessions, and visit to the schools, visit to the public places, and this type of things we should do to create the awareness among the masses. Thank you so much.
Thanks a lot.